Good afternoon, everybody. We are here in November.
It's hard to believe, but it's already kind of middle of November.
Yes. So if you've missed any of the previous videos, they're all on our website, links to them, and here's some of the more recent ones. Certainly a lot of good content there. So feel free to go back and check that out if you've missed anything.
Or just missed us.
Just so you know, it's not Frank and I, or just Frank, Lou, and I. There are many of us here. Again, we only do practice within the estate planning, elder law areas. Okay, we do everything in those areas, but we don't do divorce, we don't do general litigation, we don't do family law, we don't do personal injury, just estate planning and elder law. And so what are we going to talk about today? Just a quick review on our 2025 Medicaid numbers. And then we'll really get into why people may need to litigate or go to a hearing in a Medicaid circumstance. So Frank, I'll let you do this.
Yeah, I was going to say, this is going to be my part because I always do this part. So whenever they put the numbers on the screen, they make me talk about them. Hopefully this is kind of a refresher since we are in November and these have been our current numbers for a while. But if you're new here or you're just learning about Medicaid, in order to qualify, you can't have too much income, you can't have too many assets. So if you're a single person, the income allowance, if you want to stay at home, is $18.20 per month. If you're a couple, it goes up to $24.53 per month. If you're a single person, your asset limit is $32,396. If you're a couple where both spouses are applying, it goes to $43,781. That community spouse income allowance, that's the amount of income of a well spouse, right? Someone not applying for Medicaid when their spouse is. So that's just shy of $4,000, currently at $39,488. Assets for the community spouse range between $74,820 on the lower end up to $157,920 on the upper end. And then that bottom number is the same number it's been forever, which is if you are in a nursing home on Medicaid, you get $50 of income. That's how much you can keep. Likely not going to change because it hasn't changed since 1965.
Probably not. So how can we end up with a problem, let's say, okay? What's one of the problems? Well, a reduction could be a problem, and it would be a problem for most people, right? A reduction in what? Usually a reduction in hours.
Yeah, I mean, we pride ourselves on keeping people at home. We do a lot of education on how to keep people at home, get qualified to stay at home, create a plan to get home care if you ever need it. So imagine if you did all the planning, you got to the part where Medicaid's then providing you aids, they give you a certain number of hours, and then a few months go around, you get reassessed, and now they're trying to reduce the amount of help that you need. Can't say it's never happened, but often people, when they're receiving care, they're not in a position where they're going to drastically get better or see their circumstances improve where they need less care over time. Sometimes they kind of plateau, they don't need much more, but it's probably unlikely in most cases that they're going to need less. That doesn't mean that the Medicaid insurance companies that are involved with the assessments for all these things are going to agree with that. So just imagine that you were you had everything set up, and then Medicaid came in and tried to tell you, you're healthier than you used to be. You now need less help than you used to. Right. We're not going to give you as much assistance.
Unfortunately, I think, frankly, we'd like to see people get better, right?
Of course.
That's what we don't see a lot of. And so this does happen, but it's usually not well thought out on the provider side.
Yeah.
And they can also decide to discontinue coverage altogether, right? That's kind of a catastrophic option. But if they do that, the plan, what do you do?
Yeah. So biggest thing is you want to appeal, and we want to make sure that it's very clear that if you're appealing a reduction or a termination in services, that you do so very, 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 very quickly once you get notification that that's the action that the agency is trying to take against you. So if you want to have aid continue, meaning that your current services that were previously authorized stay in place while this appeal and this kind of fight between the two sides is going on, you have to appeal within 10 days of the date of that notice, talking about either your reduction or your termination. So 10 days is not a lot of time. So if you delay, even if it's for a good reason, if it's after those 10 days, you are then subject to whatever new things are going to do to you, and they're not going to let your aid continue. So if you're put in this circumstance, if you know someone who is put in this circumstance, or in the future, you know, or learn of somebody who is this, it's very important to get on top of that appeal right as soon as possible, just to try to keep your current services in place for as long as possible.
Right. And the biggest part of that, again, just to be clear, is that services usually don't get better, right? We're facing reductions in services across the board. So if you lose what's called your legacy status, you're just like anybody else who's applying now. So that can really be problematic.
Yeah, I think one of the biggest things that people were concerned about was when the state instituted the new 3 ADL requirement just back in September. So just catch up the viewers that if you haven't been with us for previous versions of Medicaid Monday. In September, the state rolled out new rules that if you're newly applying to the Medicaid home care plan, when you get through the financial criteria, when you get your medical assessments done, you need assistance with at least 3 activities of daily living, or you need to have a dementia diagnosis and then need monitoring, supervision, and assistance with at least 2 ADLs. That's an increase from 2 ADLs and 1 with an Alzheimer's diagnosis. So they've made it harder now for people to get qualified from a medical standpoint. And people were concerned that, well, if I met the 2 ADL criteria, I do need help. I haven't gotten better, but I don't need 3 now. I wouldn't qualify under the new rules. Am I going to lose my benefits? Well, under all the guidance we've seen, if you were already in the system, on the programs, enrolled with a provider, you should be granted that legacy status and your benefits should continue. But if you have a disenrollment, right, if you become even without coverage for even a day, then you would be treated as a new enrollee, and then you would be treated under the new rules where then you may not assess properly. So we haven't heard of anybody that's being proactively kicked off benefits unless there was due to a change of their enrollment status. So just to throw that out there for all the people that are watching, if you're hearing otherwise, that would obviously be something that would want to be appealed and dealt with very quickly if that's happening.
So other reasons to get denied, right? Denied due to income. We don't see this very often.
Hardly ever.
Have to be very, very high income for that really to be an issue.
Yeah.
Denied due to assets. Yes, this happens. Okay. Especially when people do their own Medicaid application, they don't get assistance from a lawyer.
Yeah.
Right. Approved, but with a look back penalty. So this means that you've given money out, generally speaking, or some form of asset out. Doesn't have to be cash, right? Could be land, could be anything. People don't really understand that sometimes. But that means the look back penalty means there is a period of time where you're eligible because you're now under the threshold and you now need services, but you don't get any services because you've done things not the right way, frankly.
Yeah. And up till now, we've only been concerned with the look back and the penalty associated with the look back on nursing home cases or chronic care cases. But as we've been talking about on and off for a long time since 2020, they did pass the rules in 2020 to institute a look back period for Medicaid home care. So those are still not in place. There still isn't much guidance as to when and if they are coming. We just anticipate that they're likely to be coming just because of all the changes we're kind of seeing in the world around us. So if they do institute that look back penalty and look back period for home care to be 30 months, so half of the 60-month current look back period for nursing homes, we may have to become more involved with clients that are getting hit with penalty periods because of asset transfers when we're looking at home care applications or community benefits because of that new imposition of the look back period.
And one we don't see a lot of, frankly, I don't know that we've seen any for lack of medical need, right? Because that's something that we vet pretty hard ahead of time.
Yeah.
And people don't usually come to us unless there's an actual need.
Yes.
But insufficient hour determination, yes, we deal with that on a regular basis.
That's certainly the most common reason we've had to go to hearings and do appeals in my tenure here at the firm. And just to kind of piggyback on Aaron's point, if we do have a, I don't know, borderline case, maybe the right way to put it, where we're not sure that that person would properly assess from a medical perspective, there's usually some prospective work that we might want to do involving someone like a geriatric care manager or a professional health advocate, as they're now known, to maybe vet that a little bit. Because if there's no real way for success there, then why go through the application process and everything that goes with it if we know that there's no real path forward due to the increased medical rules? The other way is to obviously just make sure that those assessments are being done properly, that adequate information is being presented. And that would be another reason to involve that professional healthcare advocate during all stages of that enrollment period, just to make sure that they're not going to ding someone for not having medical need if there truly is one.
So can you go to the courthouse immediately? No, you cannot. Okay.
Unfortunately, for many cases, you cannot.
So the appeal system is set up for delays, okay?
Yep.
And those delays don't benefit the user, right? The person on Medicaid, they benefit either the government directly or the managed long-term care plan working for the government, right? So first thing you do is do an internal appeal. Almost never do they change their mind and say, you know what, we got this completely wrong. It does happen.
I've seen them where they will partially change their award. So just for instance, right, if you have someone approved for Medicaid for home care purposes, let's say they're awarded 6 hours a day. Everyone thinks they really need 18 hours a day. First step is this eternal appeal. Maybe the plan comes back and says, you know, we considered everything. You're right. 6 hours wasn't adequate. We're going to give you 8.
Right. But that's a game, right?
100%.
That game is preordained from the minute that they did.
Yeah.
That.
They're trying to appease you to make you then continue or go away, right? Take what you've been given and politely leave.
Right. Exactly.
But that doesn't mean that that's an adequate or proper resolution to that case, right? If the need is truly 18 hours rather than 8, then I would suggest we continue on with the appeals process.
Right, which is then a fair hearing.
But very rarely do I see anything with an internal appeal just saying, you know what, you're 100% right. We shouldn't have given you 6.
Right.
We're going to give you 18.
Right.
We're sorry.
Yes, that doesn't generally happen. Okay. Internal appeal. It's pretty easy to request an internal appeal. We are given a writing when you're getting an adverse determination or any determination.
Yes.
So,
yeah. So typically when you get that form in the mail that tells you the bad news that you haven't gotten the result that you were hoping for, it should be clearly outlining the next steps to go through the appellate process, including the form itself to actually request the appeal. It actually talks about the reason behind the reasoning of the company to not award the hours. And then it will give you all the information on how to correctly file everything, whether that's calling. We just suggest that if you call, you also should confirm it in writing because we want to make sure that they just don't make it up down the road that like, hey, we never got your call.
Right.
But you can also fax in a request. And Aaron always jokes that I'm the last person on earth that still faxes things, but you can fax things.
You have a home fax machine, right?
Yeah. Or obviously you can email the request, or you can actually just write to the plan, but you want to make sure that you're having that return receipt requested because again, you want to start building that record to show that if the plan or if the appeal goes sideways and you're not getting adequate work done on the appeal, that you can show I did this properly, I did this quickly, and now I'm kind of just stuck in the middle, but at least it will give you more rights going forward.
Right. And it is extremely important to know your dates and your deadlines. Okay. I feel like there's an old legal commercial that said you have important legal rights, but you may have to exercise them now.
Yeah.
You know, so you can't wait a year.
No.
Can't do it. And you can't go back.
No, that's why I tried to be very clear with my bold capital letters on the bottom of the slide. Keep track of your dates, right? More than anything, keep track of your dates because the last thing you want to do is miss a date. Because if you miss a date, there's almost usually very little, if anything, you can do about it other than restart the entire process and kind of go through everything that you just went through without the services, without the increased services, maybe without any services at all. So while it may sound like it's not a big deal, like it's not like this is not hard to get right, but it's so important that you get it right and that you do not get it wrong.
It's also easy to get wrong. That's, So what do you need to do? Just like any appeal, you need to build a record. Okay. Some of that record can be testimony at the hearing, right? But that may not be your strongest evidence. Generally, medical determinations are strong evidence. If you can get something from a doctor saying that, 18 hours is what's needed or 12 hours is what's needed. And you're going to need to show that other people aren't around, maybe, too. That happens. So, but the burden is then on you, right? To show why the other determination is wrong.
Yeah, like one of the things that I love to see when we do the appeal, if we have to get to this part, is to see what the tasking tool says, right? What did the assessment tool say that was done by that nurse when that person was enrolling with the insurance company? because a lot of times there's just blatantly wrong information on it.
Right, it's manipulated.
Right, like there's tons of, I can think of just about every case that I've ever taken to appeal with, where it will say so and so is independent of, and then list off that activity of daily living. So they're independent for showering, they're independent for ambulation, they're independent for changing their clothes, right? Or they need minimal assistance. When you have the family and possibly even the Medicaid recipient themselves saying, I haven't been able to do that on my own in 3 years. Like,
Right.
of course I need help with that. So it's unfortunate that it comes to nitpicking to that degree, but it's something that you want to make sure that that assessment's in the record. It should be, because the plan should be putting it in there if you don't. But one, don't rely on the plan to do your job.
Right.
Do your job yourself, or hire attorneys to do your job for you. But the other thing is, not only just put it in the record as to what the problem is, then explain why it's a problem. Say why it's wrong. Just showing the judge the same piece of paper from 2 different places doesn't help if there's no context as to why it's actually wrong.
Right. So you have to be provided with the evidence that they used, essentially, to make their determination, right?
Yes.
And then usually it's our job to pick that apart, right? That's really where you need an advocate. It'd be very hard to do this on your own.
Yes. And I can say, just from personal experience, I can think of at least 1, if maybe 2 cases where we were set to go to hearing. I think it was like the day before the hearing, and we just got delivered the documents that were supposed to be delivered like a week or 2 before then. And we had to then go and request some additional time be given, so that way we just had the ability to review what the plan was saying. It's very hard to argue against something where you don't know what the other side is going to say. Now, sometimes, depending on the circumstances, you may not want to ask for additional time, or maybe you want some just time during the hearing to do some review. But that would be something that, again, you just want to be mindful of. It's very hard to make an argument or to bring a fight against the other side if you don't know what they're saying or why they're saying it. So you want to make sure that you have all the other side documents, as well as anything that you want to put in front of the administrative law judge.
Exactly. But as Frank was intimating, time is not generally on your side to wait around for these things, right? If you are losing care or you don't have the care that you need, you usually have to act as fast as possible, because that situation is not going to get better.
Right.
So how fast or how not fast do they have to decide, right? So 30 days again. So it's going to take at least 2 weeks to even get a hearing.
Well, it's months now.
Right.
Yeah, months.
But so you could be 6 months down the line before you get a determination.
Right. And this is and this just to kind of goes to the point of, this is why aid continuing is so important.
Right.
Because if it takes 6 to 8 months to get on the appeal schedule before the administrative law judge, if you've got aid continuing, well, then your services at least stay at the level that they were while this is all getting decided. Right. If you lose those 10 days, or if you lose the aid continuing because you didn't make the right, or you didn't ask for the appeal within that 10-day period, you could be completely without services or drastically reduce services for all these months that it's taking to get in front of the judge and have your appeal. So just to go to show. And then you can expedite things. You can ask for an expedited appeal or a fast track appeal. They have to be decided within 72 hours, but the plan can request an extension up to 14 days, just because there may be other things that they have to collect medically or from other agencies or things. So but then they have to inform you of the delay, tell you why that there's a delay, and then the person asking for the appeal has also given the ability to then file a grievance, right, saying why the delay is not adequate and should be.
And they only do that on Festivus.
If only.
Yes. So just to put that in plain English, right? You're saying this appeal is very important, and they come back and say, well, slow down a little bit.
How important is it?
Yeah, well, it may be important to you, but it's not quite as important to us. So we're going to slow you down. Sad, but true.
And I wish that this was probably more likely to happen than hopefully it is in practice. But essentially, if the plan doesn't do what they're supposed to do in the time that they have to do it, then you kind of win, right? And then you can just go to fair hearing at that point, because they haven't complied with their timing requirements. So while you may not get the result that you wanted, but if things just aren't progressing as timely as they need to be, then you're not you don't have to go back to the plan and kind of keep going through the same steps for them to ignore what they're supposed to be doing.
Right.
Without another remedy to go forward towards getting resolution.
I mean, to be fair, the internal appeal is weighted towards the plan,
Yes.
right? Because it's an internal appeal. And you want to get to the external appeal really as fast as you can. And they know that, obviously, because you have a much better chance on the external appeal.
Right. So speaking of an external appeal, we did put a slide here about that. So essentially, it's a step that can be taken after the internal appeal has been decided not in your favor, but you don't maybe want to go all the way up to a fair hearing, or you want to take some intermediary steps between the deciding of the internal appeal and a fair hearing. So that's where you can ask for an external appeal. They're administered by the New York State Department of Financial Services, which is the agency which regulates health insurance and other long-term care insurance. So they do their appeal more from like the medical side, from like the insurance plans. Their appeal is done completely on paper. So as much as Aaron was giving really good advice just a few minutes earlier about building that record, the record I think becomes even more appropriate and important when you're dealing with an external appeal, because now you're dealing with potential people that are going to be making a decision as to the merits of the case that aren't overly familiar with all the Medicaid rules or standards as maybe some of the other people that are involved in this process. So you may want to look into this, but the nice thing is that whether you want to do this or you don't, that if you file for an external appeal, it doesn't take away your ability to also go to fair hearing.
Right. And that's really where we're trying to get ultimately.
Yes.
It used to be a lot easier to get to a fair hearing. We used to get to fair hearing much more quickly.
Yeah.
And just for some of you that maybe have never been through this, it's not in a courtroom.
No.
In fact, you're not usually all in the same room anymore. I mean, when Frank and I used to do these, I guess pre-COVID it was, right? We would go to the local Medicaid office and sit in a room and still talking to a telephone. But the ALJ was usually there.
Yeah, you got all the parties typically in the same room.
So,
but now they're all done, at least all the ones I've done since COVID and the shutdowns happened have all been completely on the phone with all the parties all spread out, which at times it's not the biggest deal. On other ways it might be better to all still be in the same room. So I know if possible, when I have done hearings by the phone, sometimes I will have our clients come and sit in the same room as me. That way we can still see each other. We can still communicate if we need to. That way it's not all through the phone line, but it doesn't necessarily have to be in person. Although I think there are still procedures to request it in person if you really want to. But
sometimes you can resolve it if you're all in person. Right?
Yeah.
I think that the one case that I'm thinking of, the local county was strongly encouraged to resolve it in our favor. And they declined to do that.
Yes.
And then guess what?
It didn't go well. And just to go back for just a second. So if you're going against a plan decision and you have that bad internal decision, right? You have 120 days to make the appeal for a fair hearing at that point. So that is a much more prolonged amount of time.
Right. But if you wait 120 days to make your appeal,
how important is that?
Right. Yeah, I think you're undercutting your argument, right? That you need assistance.
Exactly. Plus, again, you're going with the reduced services or no services during that 120 days. Right. On top of it, not looking good, it may not actually be good.
Correct.
Either.
Correct.
So that's about plan appeals. So if you're dealing more with a decision made by the local Medicaid office, so the Department of Social Services, when you're dealing with upstate agencies like we frequently are, right? When you get your denial notice, whatever notice you're getting from the county that you don't agree with, because sometimes it's an approval, but it's an incorrect approval, they're going to have the fair hearing rights outlined on that notice. Sometimes they'll actually even tell you, in addition to having the 60-day period to ask for the hearing, they'll actually tell you what date is the 60-day mark, so that way you don't have to go into an app and figure it all out, but they don't always do that. But just again, kind of show that, again, you have some time if you want to go against an agency decision when it's the Department of Social Services, but you don't have lots and lots and lots of time.
Exactly.
So you don't want to miss your dates. So we wanted to kind of just show some examples of maybe how this kind of just looks in practice. So the first one, this is our person that's not getting their adequate services approved. So Jane, she was approved in March for community Medicaid, or she applied and then she was approved. But she was then given a transfer penalty, right? So then we asked for a hearing. It was held before the law judge, and then we would get a result. We don't have to go through the internal appeals, anything like that, because again, you're appealing that county decision on a chronic care, so a nursing home, Medicaid application, ultimately how they arrived at that 6-month penalty.
Right.
If you don't win at fair hearing, you can go for what's called an Article 78 proceeding.
Which is in a real court.
Which is something that we have not had to do since I've been with the firm.
No, me either.
But I know Lou has done them previously.
Yes.
But I don't think it's been more than a handful, just because they haven't come up.
And that takes place in Supreme Court.
And then secondly, this is our community example. So again, you had John, he was approved for Medicaid in the community. He then enrolled with his managed long-term care company after he was assessed by NIA, goes through all that process. They give him 4 hours a day, but he thinks he needs 12. So then the MLTC, they give him his initial adverse determination. He's then going to appeal that. If that's then appealed, which in this fact pattern it was, he's going to get that final adverse determination. And then once he's got that, now he can file for the fair hearing, where then he can go before the judge with counsel, create the record, go through all the things that are necessary then to have that argument in front of the judge. And then again, if that decision's unfavorable, you still can go up to the Article 78 proceeding in Supreme Court. Hopefully it never comes to that.
All right. And that is the end of the presentation portion of today. But there'll be one final one for the year. And it'll be everybody.
If you like to get the whole group back together for the end of the year.
Yes. So if you tune in, we'll be talking about what is going to change and why you should act now.